Okay. In 24 CR 2161, you were Brandon Lafleur?
Yes, yeah.
See, you were here before. You were charged with a third degree felony of injury to a child. Have you hired another attorney? That's what.
No, I had applied for
What?
the point for you.
Why? You're not employed?
Yeah,
Are you employed?
Yes, I'm employed.
So why do the taxpayers pay for your mess? That's not right. I'm a taxpayer. I don't think much of that. You've been charged with a crime, just like anybody who has a mess. You're a grown up. You got to fix it.
I understand that.
Not let 250,000 people pay for your mess.
I understand that.
It's not on my watch. That's not going to happen. Where do you work?
At M&P.
Okay. And how much do you make an hour?
1950.
Uh-huh. Yeah, that's 20 grand. That's 50 grand in a year.
Well, Your Honor, I hired a lawyer, but I couldn't keep up with his pay.
Well, there are other lawyers out there who can work with you. You go out and hire. We were here before, looks like on June 11th. What is the defendant's bond, please, on this? Brandon Lafleur? The state know?
$15,000.
I'm looking at this probable cause affidavit, and this is about one of the most disturbing things I've seen in my career. Okay, you're charged with the third degree felony of injury to a child, and it alleges that you intentionally and knowingly caused bodily injury to a child younger than 15 by shoving and pushing the child out of a moving automobile. So I go to the probable cause affidavit, and I don't think I've ever seen such a thing in my career. But you do this long enough and everything comes around, and I've handled about as many cases as any lawyer and judge my age, but I've never seen such a thing. So you're driving a vehicle, and apparently,
Allegedly, they're saying I was driving.
did you interrupt me just then?
No.
Let me speak and you'll have a chance. I'm going to read what the probable cause affidavit that's filed in this record by the police that investigated. So apparently you had a paramour girlfriend who had a child. I'm sorry, her granddaughter was in the car with you. While in the vehicle, you and the lady began to argue. It is alleged that you struck her in the face, causing pain and injury. You struck a lady. Who does that? That's so ungentlemanly. But you need to pick on people other than girls. Then that caused her to fall out of the vehicle, leaving the 1-year-old child in the passenger seat. Then, according to the lady who was thrown out of the car, you tossed the 1-year-old out of the car while you were driving the vehicle, causing the 1-year-old child to injure the child's face. Are you kidding me? You shoved a 1-year-old infant out of a moving car?
No, Your Honor.
No, that's what this says, and that's what the grand jury indicted you for. So okay, hold on, let's see. The child has facial injuries, and according to this, caused by what you did. Did the child rub her own face on the road? Is that your story?
I have no idea.
Well, the grand jury thinks otherwise, and the police that investigated it thinks otherwise. But I must say, I'm appalled. I can't imagine throwing throwing a one out of the car in the first place. That's so ungentlemanly. But a 1-year-old infant, a helpless infant, tossing out of a moving vehicle, and then the child's face is injured? What's his bond?
$15,000.
It's $100,000. It is changed based upon the circumstances to $100,000. On this court's watch, you will not harm an infant, intentionally harm a 1-year-old infant and toss them out of a moving vehicle. The grand jury says that's what you did. You're presumed innocent. I wrote the lead article on that. That's blessed to me. But the grand jury says probable cause exists for that you did this. And based upon probable cause, that's how a case moved forward. Bonds are based on the charging instrument, probable cause, and criminal history. This is one of the most disturbing probable cause affidavits I have read in my career. And I'm going to treat you like I would treat anybody in the same circumstance. Somebody charged with throwing a 1-year-old out of a moving car and causing face injuries is going to be held strictly accountable on my watch. So your bond is $100,000.
But the
Plus-
affidavit is not true.
The affidavit is not true. So now you're saying the police committed perjury. Well, we can prove that. That can all be provable later. But right now, we're going to trust what the police officers stated under oath and what the witnesses stated. You'll be taken into custody. If you post your bond, you must be at home. I don't want you driving people around in your car. You're dangerous, especially to 1-year-olds. You must be on home confinement. You can have a GPS device and you can go to and from work, to and in the most direct route possible, to and from food, to and from your lawyer that you may hire or who's ever going to represent you, and to and from court in the most direct route possible. Those are the normal orders the court gives when somebody's placed on home confinement. But anyone charged with throwing a 1-year-old out of a moving car is frighteningly a threat to everybody's well-being. That's the orders of this court. And the next event, do you have a lawyer at all representing?
No, Your Honor.
Okay. Okay, if you're unable to hire one because of what the orders of the court, fill out an indigent form and I can get somebody to represent you immediately.
Your Honor, I did fill out one the last time I was here.
Who was appointed?
Nobody contacted me. I even told my bills bond I was not contacted. They said they'll make a note.
Where would the indigent form be that he filled out earlier?
Judge, I'm unsure if it's not in the file, when he's arraigned at the jail.
Where did you fill it out at?
Oh, next door.
Oh,
It wasn't in there.
okay. That's,
Yeah.
God knows where it is now.
Judge,
You fill out another one right now, before you leave, before we take you out, fill out, then I'll get somebody.
He has a
appointed.
misdemeanor case with him.
Sir?
He has a misdemeanor case.
yeah, so it was
That's where I
probably in the,
Oh, he has a misdemeanor case?
it was probably in misdemeanor court that he did
And
that.
John
Yeah.
West, would you be so kind to talk to him before we leave? I'm gonna assume he's going to be allowed indigency under these circumstances, but here's the file to look at. And Mr. West is a very good attorney and he is one of our indigent defense lawyers, a public defender. So I want him to talk to you before we leave, sir. And I'm going to reset this for an announcement in 4 weeks. John, if there's any other appearances you feel like he needs to make sooner, let me know. But this court can't ignore the extraordinary, extreme, serious circumstances concerning what the court has in its file in the probable cause affidavit, which is what it relies on. That is all. You're taken into custody.
And
And Brand, well, hold on. I have,
Will I be able to,
You say you're taking me into custody?
Yes, you're in custody until you can post a $100,000 bond. You just can't write a check for it.
And just like that, the judge makes it crystal clear this isn't a debate over guilt. Today, it's about the allegations, the probable cause, and keeping the child safe while the case moves forward. With bond jumping from $15,000 to $100,000, the pressure has officially skyrocketed. But what do you think was the judge right to take such a hard line?
Here.